You know, sometimes a case that ends up in the Supreme Court starts somewhere really simple, like with a tank of cooking gas. Today we're going to unpack a case that started with an undercover police sting and ended with a huge question. When a company cheats you, who really pays the price?
So this really gets to the heart of it, right? When a company breaks the law, who should face the music? Is it the employee on the factory floor, the manager who's running the show, or the people up in the boardroom setting the strategy? Well, this case gives us a surprisingly specific answer, so let's dive into how it all got started.
So this whole thing didn't kick off in some stuffy courtroom. Nope. It started on the ground, at an LPG refilling plant in Quezon City, where the police had a hunch that something just wasn't right. Okay, so the police didn't just rush in. They were super methodical about this. After weeks of watching the place, they set up a classic test buy. On July 15, 2006, a few undercover officers went in with 4 branded LPG tanks. They watched the whole illegal refilling happen, and, this is a huge detail, they got official receipts for it. That was proof positive the company was refilling tanks it had no business touching. But what the police found next showed the crime went even deeper. And get this, when the officers weighed those freshly filled tanks, they found out they'd been shorted. One was missing a whopping 1.3 kilograms of gas. So the company wasn't just illegally refilling tanks, it was also deliberately cheating its customers on the amount they'd paid for. All right, so the police have rock-solid evidence of a crime, but now they have a totally different problem. Who exactly do you arrest? The investigators decided to aim high. They charged Antonio Del Rosario, who was the general manager actually running the business. But they didn't stop there. They also went after 3 members of the board of directors. And that decision, right there, would become the central legal battle of this entire case.
So the board members' defense was pretty straightforward, and honestly, it sounds kind of logical at first. They basically said, hey, we're just incorporators. We set policy from way up here, but we're not involved in the day-to-day nitty-gritty of refilling gas tanks. How can we be criminally responsible for something that happened on the plant floor?
And that question, well, it sent the courts digging deep into the law books to figure out where exactly corporate responsibility begins and where it ends.
And it all came down to the exact wording of the law, specifically Batas Pambansa 33, which handles the oil industry. And you gotta see how specific this is. It literally names the president and the general manager as the ones who are criminally liable. Now notice who isn't on that list, a regular board member.
So here's how the Supreme Court broke it down. You've got the board of directors over here. Their job is policymaking, the big picture strategy. But then you have the operating officers, like the general manager. They're the ones managing the day-to-day business. The court saw a really clear line between setting the overall direction and actually running the operations where the crime happened.
And to back this up, the court used this classic legal principle with a fancy Latin name, expressio unius est exclusio alterius. It sounds complicated, but the idea is actually super simple. It just means that when a law specifically lists certain people or things, it's assumed to be intentionally excluding everything else. Since the law named GMs and presidents, but not board members, the court figured that was on purpose.
So, with that logic, the court made its first big call. The charges against the board members had to be dropped. Under this law, only Antonio Del Rosario, the general manager, could be held criminally liable. But hold on, the legal battle wasn't over just yet. Okay, so the board members are off the hook, but the prosecutors still had another fight on their hands. See, they had charged the company with 2 separate crimes, but the defense was arguing that it was really all just one single illegal act. All right, so here's puzzle number 2 for the courts. When you illegally refill a tank and you short the customer on the gas, is that 1 crime or 2? The first prosecutor thought it was all part of the same thing, but the Supreme Court saw it very differently.
Let's break down the court's thinking here. On one hand, you have illegal trading. That crime is all about authorization. You're refilling a Patron tank without Patron's okay. But underfilling, that's about quantity. You're putting less gas in the tank than you should. They're based on 2 completely different illegal elements. You could illegally refill a tank to the perfect amount, or you could be a totally authorized dealer who decides to underfill one.
And you know what? The evidence actually lined up perfectly with this idea. That undercover test buy, that proved the crime of unauthorized refilling was happening. But later, when the police searched the whole plant, they found a stash of already underfilled tanks just sitting there, ready to be sold. That was a completely separate piece of evidence for the separate crime of possessing underfilled products.
So, the Supreme Court's answer to puzzle number 2 was crystal clear. These are 2 separate crimes. And that meant the general manager couldn't get one of the charges dropped. He could be prosecuted for both.
All right, let's put a bow on all of this and look at the final verdict that came down from the highest court in the land.
So here's the bottom line. The general manager, the guy running the daily operations, can face prosecution for both crimes. But the board members, the ones not directly involved, they walk free, charges dropped. The huge takeaway here is that this particular law draws a really bright line. It targets the operational managers on the ground, not the policymakers up in the boardroom.
And that leaves us with one last nagging question, doesn't it? The law might be clear, but ethically, it's a lot more complicated. I mean, if a board of directors creates a high-pressure environment or a corporate culture that kind of encourages cutting corners to boost profits, where does their responsibility really end? That's a question this case and this law didn't answer.